Hello, everyone. Welcome to the Centre for Resources, Energy and Environmental Law Annual Lecture 2021. It is with great pleasure that we have Emeritus Professor Nigel Bankes speaking to us on comparative climate litigation, Canada and Australia. Before we begin this lecture, I would like to pay my respects to the traditional owners of the land and waters on which all of us are situated. I know Nigel has also been deeply involved in Indigenous rights and Indigenous peoples' law in Canada. So it's with pleasure that I can also extend the welcome to country between Australia and Canada today. I'm Lee Godden. I'm the Director of the Centre for Resources, Energy and Environmental Law. I have a couple of housekeeping things just to remind you that this webinar is being recorded. As it's a webinar, if you have a question, and we certainly encourage those, could I ask you to put those in the chat, and we will have a question period at the end of Nigel's lecture. So without further ado, I'd like to introduce Nigel. Nigel and I have been colleagues for many years in a group called the Academic Advisory Group to the International Bar Association. And it has been a wonderful collaboration of academics and researchers across many, many countries. So it's with great pleasure that I'm able to introduce Nigel today. And I was also very lucky that I was able to arm twist him as he retired. So Nigel is Emeritus Professor of Law at the University of Calgary in Canada, where he taught from 1984 until his retirement in June of this year. Nigel has wide experience in teaching, covering a variety of subjects, including property law, natural resources law, oil and gas law, energy law, international environmental law, and Aboriginal law. So you can see that Nigel's perspective and teaching and research is very closely aligned to that of CREEL. Nigel was also the holder of the Chair of Natural Resources Law at his university, and previously the Vice Chair of the Board of Directors for the Canadian Institute of Resources Law and a member of the Education Advisory Board of the Association of International Petroleum Negotiators. So you can see that Nigel's experience extends not only from academic expertise, but across into critical areas of legal professional life. Nigel was awarded the Clyde O. Martz Teaching Award by the Rocky Mountain Mineral Foundation, that is US and Canada, for meritorious teaching in the area of natural resources law. In 2019, Nigel received a Killam Annual Professorship for his excellence in research, mentorship, and teaching. Nigel is a Fellow of the Royal Society of Canada. So without further ado, could I hand over to Nigel now? And I think he'll take a moment to just share his screen with you. Thank you.
Yes. So thanks, Lee. I'm just looking for the presentation. Yes, there we go. And so thank you, Lee. I'd like to begin by acknowledging that I'm joining you from the traditional territories of the Blackfoot, the Tsuut'ina, and the Stoney Nakoda First Nations in southern Alberta. Thank you very much for the invitation to present the annual lecture for your centre. I am, of course, disappointed that COVID-19 restrictions still continue to preclude in-person visits, as I would very much have liked to renew my acquaintance with the city of Melbourne, with the university, and with colleagues there whom I have known for a long time. I've only been to Australia the once, and that was in the fall of 1990, some 30 years ago. And for 4 months, I enjoyed the hospitality of Professor Cheryl Saunders at the Centre for Constitutional Studies, doing some comparative work on intergovernmental agreements in Australia and Canada. And so it's perhaps fitting that I've chosen to address another comparative law topic today, but I do so with some trepidation, knowing that your faculty has, in the person of Professor Jacqueline Peel, one of the world's foremost scholars of comparative climate litigation. While my remarks will focus on litigation in Canada and Australia, and particularly Canada, it's worth recalling that there are numerous important climate change decisions being rendered by the national courts of other jurisdictions and which help frame our inquiry. These decisions include the agenda decisions of the Dutch courts, culminating with the decision of the Supreme Court in late 2019, holding that the state was in breach of its obligations under Article 2, the right to life, Article 8, right to respect for private and family life of the European Convention on Human Rights, when the state adopted an emissions target that was insufficiently ambitious in light of the IPCC's fifth assessment report and the understanding of what was required to keep global warming within 1.5 to 2 degree range. Second, we have the decision of the Hague District Court against Royal Dutch Shell in May of this year, concluding that Shell has a tort or delict-based duty to reduce emissions from its global operations by 45% by 2030 over 2019 levels. And third, we have the decision earlier in the year of the German Constitutional Court upholding a challenge to the federal climate change law on the basis that it breached the state's duty under Article 20A of the Basic Law, insofar as the federal law failed to establish sufficiently ambitious greenhouse gas reduction targets in the years leading up to 2030. And for some balance, I also recall 3 important decisions that are more deferential to state interests. These include the Heathrow Airport decision from December 2020, and also at the same time, a decision of the Norwegian Supreme Court to the effect that the state's decision to issue new petroleum exploration licenses for the Southeast Barents Sea did not violate the right to a healthy environment protected by Section 121 of Norway's constitution. And third, we have the Juliana decision in the US, where I think the Ninth Circuit of the Federal Court of Appeals has essentially stayed the case on the basis that it is non-justiciable. And this extensive jurisprudence is also supported by a growing literature on climate change litigation, including annual doctrinal surveys, such as those of Professors Peel and Osofsky, as well as contributions based on particular jurisdictions. For example, in preparing for this lecture, I found the recent articles by Kiera Parker and McGuinness and Raff on the Australian coal cases to be particularly useful. Much of the literature seeks to explain the reasons for and the significance of this case law. A common explanation lies in the change that we have seen in the architecture of international climate agreements, and in particular, the move away from the top-down binding commitments of the Kyoto Protocol to the bottom-up approach of the nationally determined commitments of the Paris Agreement. By its nature, this change focuses attention on domestic processes for setting increasingly ambitious NDCs, as well as national reporting obligations. And this domestication of responsibility creates enhanced opportunities for engagement by civil society, including through the use of domestic courts. The literature also points up how developments in the science of climate change have facilitated litigation strategies. of particular note has been the ability of the scientific community through the IPCC to move beyond the general objectives of the convention, namely to stabilize carbon emissions, by developing, first of all, target maximum temperature increases, initially 2 degrees C, now 1.5 degrees C above pre-industrialization levels. And second, the translation of that target into parts per million concentration of CO2 in the atmosphere. And third, and most recently, further translating that into a global carbon budget. That is to say, the remaining gigatons of carbon dioxide equivalent gases that can be released before the target atmospheric concentrations will be exceeded. And I think we can see the crucial role that the concept of the carbon budget plays in a number of recent cases, including the Shell decision, the German Constitutional Court decision, and the decisions of your courts in Sharma and Gloucester Resources. While the science cannot tell us what is an appropriate national allocation of that budget, the science does make the challenge that we face more concrete, and perhaps more importantly, facilitates debate and litigation about what is a fair intergenerational allocation of the remaining budget within a particular state. The concept of a carbon budget also helps with issues of causation and what we might think of as the de minimis defense. That is to say, the argument that the emissions associated with this particular project or this particular jurisdiction are so small in global terms that anything that we might do is irrelevant or does not make a causal contribution. Not so. Any emissions erode that carbon budget and increase the risk of exceeding the target, and thus the risk of triggering what the Sharma case refers to as a non-linear tripping cascade. Now, there are lots of other themes in the literature that we could pursue, but I think I need to engage more directly with the title of this lecture and comparative comments on Australian and Canadian climate change litigation. My original plan was to do this under 4 headings: constitutional law, administrative law, tort law, and what I'm referring to as disclosure law. That is disclosure obligations under pension law, insurance law, securities law, which you have highlighted in the McVeigh case and settlement. But that certainly proved to be too ambitious given the time available. So I'm going to focus my comments on the first 2, hoping that if those listening want, we could also turn to the other 2 during the Q&A. My emphasis is going to be on Canadian law, but I do hope to make enough connections across the hemisphere that we can make some comparative observations. Before turning to law, however, I think it does make sense to say a few words about Canada's less than stellar efforts to stabilize and reduce emissions. And I think we can say that this is not a happy or proud picture. And this slide, I think, provides some of the highlights or the lowlights. And first, you'll recall that Canada missed its Kyoto Protocol first commitment period obligation by a large margin, and to protect itself, promptly withdrew from the protocol just before that period came to an end. Second, Canada's subsequent commitments have not been very ambitious and have moved from a 1990 base year to a 2005 base year. So Canada's Copenhagen commitment was to reduce its 2005 emissions by 17% by 2020. Canada's first NDC under the Paris Agreement was a commitment to reduce its GHG emissions by 30% below 2005 levels by 2030, and its revised NDC filed in July is somewhat more ambitious. And finally, Canada announced a commitment to net zero by 2050 and enshrined that as of June this year in new and I think important federal legislation, the Canadian Net Zero Emissions Accountability Act. You will be more familiar than I with the details of Australia's responses to the challenge of reducing emissions. But I think it's fair to say that it is equally episodic and lacking in ambition. And indeed, the Climate Action Tracker rates the commitments of both countries as highly insufficient, with Canada coming out marginally ahead of Australia on some of the subcategories. I'm not going to read this slide, but I will say that I particularly enjoyed the parliamentary library chronology, which is listed at the bottom for the detailed blow-by-blow account of the development, progress and reversals in your climate policy. So with that, turning to the first area of law, constitutional law. And constitutional law within a federal state is preoccupied with the power to make laws and the division of legislative power between the federal order of government and the state or provincial order of government. But in those jurisdictions such as Canada, with an entrenched Bill of Rights, constitutional law is also concerned with the question of whether the actions, and perhaps more significantly, the inactions of governments are consistent with, in our case, the Charter of Rights and Freedoms. But to start with division of powers, it's quite clear that both orders of government in Canada can make laws with respect to some aspects of GHG emissions. And I take that to be the case for Australia, although in each case, the federal government must take care to ensure that the legislation is tailored to a relevant head of power. And in the case of Canada, we've seen protracted litigation with respect to the validity of the federal government's principal instrument for curbing greenhouse gas emissions, namely carbon pricing as implemented through the terms of the Greenhouse Gas Pollution Pricing Act. This legislation establishes two forms of carbon levy, one for large emitters of greenhouse gases that requires emitters to pay the levy on emissions above a prescribed intensity standard, and the second, a fuel charge imposed on carbon-based fuels. And the current price is $40 a ton, rising to $170 a ton by 2030. The legislation is framed as backstop legislation, such that it will only apply in a particular jurisdiction to the extent that that jurisdiction fails to adopt measures of equivalent carbon price stringency and the breadth of coverage. And the legislation was designed in this way to offer provinces a measure of choice as to whether they wanted to go with a cap and trade approach or a levy and tax approach, so thereby reducing the level of federal intrusion. But the goal was very much to establish an economy-wide price for carbon. And while the federal government could likely have justified some form of greenhouse gas legislation as on the basis of its taxation power or on the basis of its criminal law power, it chose instead to try and justify it on the basis of what is known as the residual head of power. So unlike Australia's constitution, Canada's 1867 settlement creates two lists of heads of power, one for the federal parliament, section 91, and one, section 92, for the provincial legislatures. But section 91 also reserves in its introductory text a power to make laws for the peace, order, and good government of Canada for matters not coming within matters assigned exclusively to the province. This residual head of power, also known as the POG power, obviously has the potential to upset the balance within the federation if it is given too broad an interpretation, and accordingly, the courts have been very cautious in its application. Over the years, the courts have identified three circumstances in which the federal government may invoke POG: national emergencies, new subject matters, such as aeronautics, and matters of national concern characterized in particular by the inability of the provinces to effectively address the matter. And in this case, the federal government sought to rely on the national concern branch of POG. And the case came to the Supreme Court of Canada as a result of 3 separate reference cases initiated by the provinces of Ontario, Saskatchewan, and Alberta, all headed by conservative governments in contrast to the Trudeau Liberal administration at the federal level. The majority of the court, in a decision handed down in March of this year, accepted the validity of the legislation, characterizing the subject matter of national concern as establishing, and this is the bottom of this slide, establishing minimum national standards of greenhouse gas price stringency to reduce greenhouse gas emissions. And the matter is deliberately framed narrowly to avoid trenching on provincial powers, but the characterization is also somewhat self-serving insofar as it adopts the language of national standards, thus, if you like, almost ensuring provincial inability. Clearly, a province cannot make a law in relation to national standards. So while the case is of considerable interest and importance in national constitutional scholars, what is its broader significance, especially to an international audience? I think that perhaps the principal international significance of the case is simply its reliance on jurisprudence from other jurisdictions to help rebuff a version of the de minimis argument. In this case, the argument that an individual province's emissions would be so small that they could not cause measurable harm or have a tangible impact on another province. And in rejecting that argument, the majority referred to Massachusetts and EPA and the agenda decisions, as one might expect, but also referred to the Gloucester Resources Rocky Hills decision. And parenthetically, I note that Chief Justice Preston, in turn, references the Supreme Court decision in the recent Narrabee Gas project case, again for the same proposition. The majority doesn't expressly adopt the language of carbon budget, but it did endorse the proposition that every emission of greenhouse gases leads to an increase in greenhouse gas concentrations in the atmosphere and thus contributes to the global harms of climate change. The case also recognizes climate change as an existential threat, and commentators have noted that the result enhances the perception of Canada as a federal state able to make credible commitments in international negotiations. My understanding is that Australia has not seen similar climate change litigation, although the literature certainly recognizes that the Commonwealth Parliament has broad lawmaking powers for the environment under the Foreign Affairs power, which Canada doesn't have, and your company's head of power, but both have their limits. For example, while the Foreign Affairs power can be used to implement binding international obligations, most of the obligations that the Paris Agreement establishes are procedural in nature rather than substantive. Nevertheless, at least one commentator has observed that it should be possible for the Commonwealth government to pass what some refer to as framework legislation or accountability legislation, such as that adopted by Canada's federal parliament this summer, insofar as such laws are aimed at ensuring the elaboration of science-based and increasingly ambitious NDCs. But there's also the political willingness of a government to fully exercise its powers. Thus, as I understand it, the principal Commonwealth legislation in this area is the Environment Protection and Biodiversity Act, which contemplates federal involvement with respect to controlled actions that are likely to have a significant impact on a matter of national environmental significance as listed in the Act. And while that list includes World Heritage sites, there is no explicit greenhouse gas trigger, with the result that considerations of climate change only arise as a matter of federal law insofar as the GHG emissions of an activity may impact a matter of national environmental significance, such as the Great Barrier Reef Marine Park. I understand that the review report on the legislation did consider the possibility of an amendment to the Act to include a climate trigger, and I'm not sure whether that continues to be a live debate in Australia. Turning now from division of powers cases to rights litigation, given that Canada has a constitutional Bill of Rights, it's hardly surprising that we are seeing rights-based climate litigation coming forward. And indeed, we have 4 such cases moving through the federal court and provincial superior courts, although all are in fairly early stages. The 4 cases are the Environnement Jeunesse case, a decision of the Quebec Superior Court, the Mathur case in the Ontario Superior Court, the La Rose case in federal court, and finally the Dinezé case also in federal court. I will organize my remarks around these cases around 5 questions. So the first question is, who are we seeing as plaintiffs and defendants in these cases? The plaintiffs in 3 of the 4 cases are children and youth. The plaintiff in the Dinezé case are 2 First Nations communities. The defendants in 3 of the cases are the federal government, but in the Mathur case, relief is sought against the government of Ontario. Of the 4 cases, the Mathur case is in many respects the most specific insofar as it is concerned with the decision of the Conservative Ford government in Ontario to roll back more aggressive GHG reduction targets adopted by a previous Liberal government. As for causes of action, all 4 cases rely principally on 2 sections of Canada's Charter of Rights. Section 7, the right to life, liberty, and security of the person, and Section 15, the equality rights provision, the latter premised on the claim that the plaintiffs, as children and youth, are being subject to unequal treatment. While 2 of the cases also reference public trust duties, that's the Dinezé and the La Rose case, these cases are, I think, very much consistent with the rights turn that has been observed in the literature. One of the challenges for the plaintiffs is to particularize their claims and to specify the government laws and policies of which they complain. This has been easiest for the Mathur plaintiffs insofar as they can point to specific rollback legislation. It's been more challenging for the other plaintiffs. For example, the La Rose plaintiffs allege that a series of federal policies are incompatible with a stable climate system. The plaintiffs in all 4 cases are primarily concerned with seeking declaratory relief, but they also go beyond this and seek more proactive measures. For example, the La Rose plaintiffs seek orders requiring the defendants to develop and implement an enforceable climate recovery plan that is consistent with Canada's fair share of the global carbon budget. And one way or another, I think this gives rise to concerns as to justiciability, so the 3rd issue, which I think is the biggest challenge for the plaintiffs. So the doctrine of justiciability in Canadian law is largely focused on an inquiry into the appropriateness of judicial adjudication, or as stated in one case, the issue is one of institutional competence. The question is whether there is a sufficient legal legal component to anchor the analysis. A principal function of the doctrine of justiciability in Canadian law is to support the separation of powers as between the 3 different branches of government. Historically, This meant that the courts would not second guess the content of government policy or the government's decision to allocate resources to X rather than to Y. And the courts are still reluctant to enter into this territory, especially where judicial resolution of the issue would require government to adopt positive measures. But the adoption of the Charter in 1982 means that the courts cannot completely avoid these questions. After all, the allegation that government policies pose risks to life and to the security of the person, or impose a risk disproportionately on one generation and not others, are fundamentally legal questions suitable for judicial determination if supported by appropriate evidence. But this has not prevented governments from arguing that systemic climate cases are not justiciable, and the record so far is mixed. The courts have ruled in favor of the governments in both the Dinezé case and the Larose case, and in favor of the plaintiffs in Anjou and Mathur. In Larose, which is on appeal, the court concluded that the plaintiffs' charter claims were not justiciable, largely because of the generality of the pleadings and the multiplicity of governmental policies that led to an alleged breach of a charter-based obligation to maintain a climate system. For the court, this way of pleading the case, which emphasized the cumulative effect of government policies, was problematic because there was no clear connection to specific laws or state action, leading to the conclusion that the plaintiffs are seeking judicial involvement in Canada's overall policy response to climate change. And I think there are some parallels here between this decision and the Juliana decision of the Ninth Circuit in the US. The Mathur court, on the other hand, distinguished Larose and found the plaintiff's claims to be justiciable, largely on the basis that the Mathur plaintiffs challenged specific government conduct, namely the rollback legislation. And I think there are analogies here with the agenda decision. In addition to justiciability, the other issue that has been confronted in the case law is whether the cases are at least arguable. And to be clear, there's been no adjudication on the merits in any of these cases, but the court in Mathur, and to a lesser extent in Larose and Anjou, did offer some preliminary comments as to the substance of the Section 7 and Section 15 claims in response to the government's arguments that these claims stood no chance of success. The Mathur court declined to strike either the Section 7 or the Section 15 claims. For Section 7, the court concluded that the evidence provided in the pleadings engages each of the Section 7 rights: the right to life, the right to liberty, and the right to security of the person. For example, the right to life is engaged insofar as the applicants argue that Ontario's actions in repealing the Climate Change Act and setting an inadequate target increases the risk of death of Ontario's youth and future generations. The Mathur court was particularly concerned with the argument that the plaintiffs were seeking a positive intervention from government rather than simply have it refrain from doing something. The court's response, though, was that the Supreme Court and other courts have left open the possibility that Section 7 might, in special circumstances, require positive measures, and thus it would be inappropriate to strike the claim at this point without giving the plaintiffs the opportunity to prove these special circumstances. The court in Mathur also refused to strike the claim based on the Section 15 equality argument, recognizing that while the impugned law did not discriminate on its face, the court conceded that the plaintiffs might be able to establish adverse effects discrimination, and thus that Ontario's actions will have a disproportionate effect on youth and future generations by putting them at increased risk of various health problems due to their age. And then remedies. While in a sense it's premature to discuss the matter of remedies, the court did address the question of whether the remedies that the plaintiffs sought were within the institutional capacity of the court to grant orders requiring Ontario to set a science-based GHG reduction target in order to ensure a right to a stable climate system and a sustainable future for future generations. While the court didn't express a final opinion on the matter, the court did express the view that a court might be able to address any concerns by limiting the available remedy to declarations and by leaving it to government to determine the best means forward. And I think there are analogies there with your bushfire survivors case. So turning briefly to Australia, in the absence of a constitutional Bill of Rights, one would not expect there to be much climate change litigation with a rights focus. And that, so far as I can see, is indeed the case, although you do have at least one example of litigation based upon an alleged breach of a state's Human Rights Act. And this is the Waratah coal case, where I understand there have been some preliminary motions, but the matter has yet to be heard on the merits. And moving now to public or administrative law cases, I think we can pretty clearly the case that climate change litigation in both Australia and Canada has often engaged with the regulatory approval of carbon-based resource projects, whether those projects be new coal mines, LNG facilities, carbon pipeline applications, or in the case of Canada, large oil sands projects. And the issue has been raised most explicitly in Canada in the context of proposed new interprovincial oil pipelines, providing incremental takeaway capacity from the oil sands of Alberta to tidewater on the west coast. And while the relevant statute, the National Energy Board Act, did not give the board any explicit guidance with respect to greenhouse gas emissions, the board itself concluded that it would not take account of either upstream emissions, that is, emissions associated with the mining activities, or with downstream emissions, that is to say, what are known as Scope 3 emissions. Forest Ethics, in the second case listed on that slide, sought judicial review of that decision before our federal court, which ruled that the standard of review would be reasonableness and that the decision was within a range of acceptability and defensibility on the facts and the law. And the court gave various reasons for that conclusion, but seems to have been particularly impressed with the idea that the board only had statutory responsibilities for the physical project. We have also seen climate greenhouse gas emission issues raised in the context of coal projects. And so we have this recent decision dealing with the Grassy Mountain coal project. But I'm going to pass over that in the interests of time, because I do want to leave some time for questions. I would observe, though, the bottom bullet on this slide, which refers to the fact that since the decision in Forest Ethics in 2014, we have seen new federal energy pipeline legislation and impact assessment legislation, which will require, where federal authorities are engaged, a duty to assess whether a project will hinder or contribute to the Government of Canada's ability to meet its environmental obligations and its commitments in respect of climate change. But what we observe so far is that the preliminary guidance that we have from the agency administering the legislation is that this will include Scope 2 emissions, but will not include Scope 3 emissions. when I turn to look at the Australian case law and literature on your project cases, there are a number of things that stand out to me. First, you have many more project decisions than we do, a lot more, at both the state level and the federal level. Second, and at least at the state level, some of the most important decisions are not classical judicial review decisions concerned with the legality of the decision, but are instead reviews on the merits by a more specialized tribunal. This is the case, as I understand it, for decisions of your Land and Environment Court of New South Wales and the Land Court of Queensland, although I understand that the decisions of the latter take the form of a recommendation to the minister. By contrast, at the federal level, the process is one of more classical judicial review that doesn't concern itself with the merits of the decision. Third, I observe that assessment of Scope 3 emissions has long been required in New South Wales, following the Gray decision in 2006 and a subsequent policy decision by the New South Wales government to require such an assessment. The position, as I understand it, is less definitive in Queensland. Fourth, the mere fact that Scope 3 emissions must be assessed does not in and of itself lead to a conclusion that a project must not be allowed to proceed. And you certainly have decisions in which the decision maker has been persuaded by arguments based on de minimis contributions and market substitution. And therein, I think, lies the real importance of the Gloucester Resources decision and its conclusion that Scope 3 emissions would cause an unacceptable impact on the environment. This conclusion is in large part informed by the idea that we only have a limited carbon budget still available to us if we are to remain within a 1.5 or 2 degree world. Thus, we should not be approving projects that risk making additional carbon available to the atmosphere, especially when existing projects can meet global demand. It seems to me that this mode of reasoning is broadly applicable and helps address arguments based on leakage and market substitution that have bedeviled much of the litigation in this area with respect to Scope 3 emissions. The fact that other sources of coal might substitute for this project is simply not a reason for project approval where the global carbon budget is limited. And let me then lead to some conclusions and then open it up for discussion. So the first conclusion is that Canada and Australia have amongst the highest per capita CO2 emissions in the world, and yet both maintain emissions reduction targets and trajectories that are far from ambitious. This suggests that there is some continuing incentive for civil society to engage the judicial branch to see if it can help strengthen the resolve of the executive and legislative branches and address the mismatch between electoral timescales and the timescales associated with addressing greenhouse gas emissions. Second, climate change litigation in Australia seems far more advanced than in Canada, certainly in numbers, but also I think in terms of sophisticated engagement with Scope 3 emissions and the implications of a limited carbon budget, especially in the context of project approvals. I think judicial engagement on these issues has been fostered by the availability of specialized tribunals with the jurisdiction to engage in a review of the merits. Merits review is generally not available in Canada. Third, while both Canada and Australia have seen project-based cases and lots in the case of Australia, I think that the current emphasis in Canada is on rights-based cases, principally because they are more likely to bring about systemic change and prevent backsliding. I don't mean to suggest by this we've moved on from what some call first generation to second generation climate cases. And indeed, I'd be surprised if there's not some attempt to challenge the practice of excluding Scope 3 emissions from federal project reviews. And fourth, while these rights cases are still in their early stages, the decisions to date suggest that the principal challenge seems to be justiciability and the question of whether or not Section 7 of the Charter affords the court the authority to require a government to adopt positive measures. My own view is that the Mathor Court offers better guidance than LaRose on this point. Fifth, it's my sense that while both federal governments in Canada and Australia have seen periods where they prefer to take a low profile on climate change issues, leaving the heavy lifting to the subunits of the Federation, the Trudeau-led federal governments that have held power in Canada since 2015 have bucked that trend in the face of the stubborn reluctance of some provinces, especially resource-rich provinces, to set ambitious targets or even any targets. The result has been significant constitutional conflict, epitomized by the greenhouse gas references brought on by provincial conservative administrations against a federal liberal administration. I don't anticipate that the period of constitutional conflict in Canada has come to an end, and I anticipate further litigation with respect to federal plans to cap greenhouse gas emissions from the oil and gas sector, which were internationally announced in Glasgow. My sense is that your Commonwealth government has not felt the need to be as assertive. And finally, it's useful to reflect on what is missing in the Canadian experience to date by comparison with Australia. And I think I would point to the absence of litigation dealing with disclosure requirements and the absence of tort-based litigation against either governments or major emitters. And that brings me to the end of my prepared remarks. I've gone somewhat over time, for which I apologize, but I look forward to questions.
Thank you very much, Nigel, for that incredibly comprehensive discussion there of the litigation in Canada and in Australia. I notice we have a couple of questions in the chat, and so I'll just turn to those. But one of the things that I found fascinating is that distinction between the rights-based model in Canada, which one would perhaps expect given the different constitutional and other positions, but also that you've picked up that Australia is very much regulatory focused in terms of its project base to much of the litigation. And I think that speaks volumes about the different sort of legal cultures that we have, but also that you're dealing with particular ways in which current policy has developed in both of the jurisdictions. So without further ado, if I could turn to that question in the chat, and the overview of the cases that you've given, will they compel or encourage the Canadian government to adopt more ambitious climate policies? So, presumably this is one of the reasons why climate litigation is taking place, is to encourage reluctant federal governments to be more ambitious, but that's certainly an expressed view here in Australia. So I was just wondering if you could respond to that. Thank you.
I guess the question is whether the initiation of the litigation makes a difference, or whether it's only when you actually win cases that it makes a difference. And I guess at this stage, it's too early to say. I mean, there's a sense in which the target governments are not the most obvious target governments. The most obvious target governments in Canada would, I think, be Alberta and Saskatchewan as resource-rich provinces who want to be able to continue to exploit their carbon resources. So I think one of the things that will be interesting is to see is whether we can ginger along climate rights-based climate cases in those jurisdictions.
Thank you, Nigel. And I think perhaps if I could also offer the commentary that we haven't actually seen extensive litigation in Western Australia, which in many ways is the parallel to provinces such as Calgary, in the sense of it being resource rich, but also an economy very much driven by resources. So yes, I think it will be interesting to see whether in fact attention turns to governments that are very clearly so heavily dependent on resource economies. So thank you for that view. And if I could turn to the other question. What are Professor Bankes' thoughts on the potential for success for climate change Charter of Rights cases? So, I mean, you've offered some thoughts there, but perhaps if you could expand a little further, because I think these are areas where in Australia we're just starting to see a more rights-based focus emerge in, for example, the Torres Strait Islander context. So thanks.
Yeah, so all of the four cases that I mentioned are Charter of Rights cases. They're concerned in particular with Section 7 and Section 15. So, and I think the two obstacles. One is justiciability, and the other is the positive actions that they are effectively requiring of government if successful. On justiciability, it seems to me these cases have to be justiciable. They are raising serious questions of law. Sure, there are political overtones and they're politically uncomfortable, but they're raising clear questions of law. And I think as you see that, and here's where I think comparative law is interesting, right? Because as you see the build-up of cases in other jurisdictions where these issues, particularly rights-based claims, whether based on international law or national constitutional provisions, are held to be justiciable, then I think it becomes very hard for a Canadian court to say, well, there's something different about it here, even though we've got an entrenched charter. And on the positive action side of things, the Supreme Court and other courts have clearly said that this is open in special circumstances to raise this. And what can be more special and unusual than an existential challenge? And so that's where I think there's, in a sense, some spillover from, you know, big constitutional cases recognizing existential challenge to private law cases and charter cases. It immeasurably increases the profile and, in a sense, demands legal responses and remedies.
Thank you, Nigel. One of the things that I might offer is that when we see the use of tort law in Australia, for example, in the Sharma litigation, in some ways what we're seeing is the massaging of private law into a public function. And so while we don't have the same constitutional aspects and the rights aspects, what we're trying to do, I suspect, with Sharma is actually massage in the direction of a rights-based model, but using the parameters of private law there and negligence, to the extent that negligence clearly has obviously very clear public policy outcomes, even if courts will not always admit that.
Yeah, I think that's absolutely right. I mean, and Sharma is, of course, a fascinating case, and it will be interesting to see what the Court of Appeal says about it. I understand it's been argued, is that right? But we've yet to see a judgment. And I mean, there's a sense in which as well, they're constitutional cases, right? insofar as they're concerned with the separation of powers. And I guess what I mean by that is really this question of whether or not there should be governmental immunity to negligence-based actions directed at a public decision maker dealing with questions of policy. So there's one of the things I sort of observe, having been immersed in reading these cases over the last months, is, you know, the number of references you see to the separation of powers, both in the private law context and, of course, in the public law in the context of justiciability and the types of remedies that courts are able to craft without trespassing on the other branches of government.
We have two other questions, and so while we're just a little short on time, this one does pick up on that thread of negligence. So the carbon budget approach to causation sounds like the, quote, material contribution test to causation in negligence that to date has largely been limited to industrial accident cases, in contrast to the but-for test adopted in negligence cases more generally. And that's a comment from Eugene Tao from Melbourne.
Yes, I mean, insofar as one really encounters this in the context of either tort actions against a government or against a large emitter. And I think it's pretty clear that one needs to call in aid material contribution rather than but for if those cases are going to succeed. And I guess in Canada, I think the leading case is a case called Clements and Clements, which certainly endorses the availability of the material contribution approach in these sorts of cases.
And I think if we can just finish up with a couple of very quick questions here. There's thanks for the presentation. With the main aim of Paris Agreement and reliance on fossil fuels, do you think developing nations can take a cue from Australia on climate litigation? A small question to finish, perhaps.
It's an interesting question. And so one of the themes that you see in the literature that Professor Peel and others have pointed to is, you know, we've been concerned for the last 10 or 15 years with litigation in the north, right, and not in the south. Yet we know courts like the Indian Supreme Court have been very active in the environmental area. So I'm not so sure it's much what jurisdictions in the global south can learn from Australia or Canada, but what they might learn from other courts in south jurisdictions. I think it's, you know, important to cast the net wide and not be so north focused in our approach. I mean, I'm guilty of that too, but then I was speaking to an Australian audience, so yeah.
Thank you. And look, there's a question on justiciability, which I think you've touched on in various ways. So if you don't mind addressing that, perhaps we'll capture the questions in the chat and we'll give a response to Cresta. But I'd like to now put my chat thing down and just to say a very heartfelt thanks for the lecture today. Wonderful insights, your comprehensive knowledge of many, many issues in Canada that relate to climate litigation, from federalism to thinking about issues of justiciability. I think you've probably spent more than a month or so reading those cases, reading Australian cases. So I'm very, very grateful for the time commitment and just your depth of knowledge and understanding of those cases that was revealed today was wonderful. I look forward to a time when perhaps, Nigel, you can come and join us here in Melbourne. I wish you happiness in your retirement and a very big vote of thanks on behalf of us all here at CREEL for the lecture today. Thank you again.
Thanks, Lee, and thanks for the invitation.